Welcome to EUPrivacyForAll, Session 72 on GDPR, Articles 94 to 99, Final Provisions. Article 94 and following lay down final provisions with regard to the GDPR. For instance, Article 94 sets that the repeal of the directive will intervene 2 years from the date of the entry into force of the regulation. Article 95, regarding the relationship with the Directive 2002/58, stresses that this regulation shall not impose additional obligations. Article 96, on the relationship with previously concluded agreements, clarifies that international agreements involving the transfer of personal data to third countries or international organizations shall remain in force until amended, replaced, or revoked. Article 97 on the Commission reports makes also clear that the Commission shall submit reports on the evaluation and review of this regulation to the European Parliament and the Council and make those reports public, each 4 years. The Commission may request information from Member States and supervisory authorities in this frame. In carrying out the evaluations and reviews, the Commission shall take into account the positions and findings of the European Parliament, the Council, as well as other relevant bodies or sources. The Commission shall, if necessary, submit appropriate proposals. Article 98 on the review of other Union legal acts on data protection announces that the Commission shall, if appropriate, submit legislative proposals with a view to amending other Union legal acts on the protection of personal data. Finally, Article 99 on the entry into force and application of the GDPR stresses that the regulation shall enter into force on the 20th day following that of its publication. In Recital 170, it is stressed that since the objective of the regulation is to ensure an equivalent level of protection of natural persons and the free flow of personal data in EU, it will be better achieved at Union level, in accordance with the principle of subsidiarity, and also with the one of proportionality. That is to say, that the regulation does not go beyond what is necessary in order to achieve that objective. In Recital 171, Directive 95/46 is to be repealed by the GDPR. Each processing of personal data should be brought into conformity with the regulation within the period of 2 years. Where processing is based on consent pursuant to the directive, it is not necessary for the data subject to give his or her consent again, if the manner in which the consent has been given is in line with the conditions of this regulation. The Commission decisions adopted and authorization by supervisory authorities remain in force. Articles 32, 33 and 34 of the Directive laid down the final provisions. What should accountable data controllers and processors get prepared for? They should know that the Directive 95/46 will be repealed 2 years after the 20th day following that of its publication in the Official Journal of the European Union. National laws should be brought into conformity with the regulation within this period of 2 years. References to the Article 29 Working Party on the protection of individuals shall be construed as references to the European Data Protection Board, EDPB, or the Board. The GDPR shall not impose additional obligations with regard to the Directive 2000/58. International agreements involving the transfer of personal data to third countries or international organizations, Commission decisions, and supervisory authorities' authorizations shall remain into force until amended, replaced, or revoked. The Commission shall submit reports on the evaluation and review of the GDPR to the European Parliament and Council, notably on transfers and regarding the consistency mechanism, within 4 years after and each 4 years after the publication of the GDPR. Finally, a processing based on consent needs no new consent to be given if it is in line with the conditions set in the regulation. So the question triggered now is, will we all get ready on time for the GDPR?